All right, Jim, so just closing out the previous question into this question, what are the elements, the specific elements that make a customized LLC operating agreement? And of course, as you mentioned earlier, we are talking about a corporation in lieu of a LLC, limited liability company bylaws. But specifically, in one of these documents in an LLC operating agreement, what are the elements that make a customized agreement strong and protect the business and, of course, the business owners?
Well, thanks, Mark, for that question. I won't give away all of our trade secrets. There are good operating agreements, and then there's better operating agreements, and I'll probably tell you a little bit about something in between. Reason being is that a lot of these techniques are very highly protected and a lot of guarding going on because they're very good, and even having a video out there that tells how you're doing it is something that sooner or later could be apprehended by someone who's pursuing one of your clients, and then they could use it to try to penetrate their company because they have an idea of how it's done. So we're careful for very good reason. That's to protect those parties out there who not only use our services, but others out there who work with other attorneys who use similar techniques. So let me start out answering that question first by saying this. The first step in dealing with an LLC or a corporation in deciding how you're going to set it up is to figure out where you're going to go. In other words, you probably want to shop for a good state to put it in, because you can put some miraculous clauses inside of an operating agreement, but actually set up the LLC or the corporation in a state that ignores all of them and will cut right through them. So you have to go into a state that already recognizes the things that I'm going to tell you about and legitimizes them and says that they can be done and that they're a legitimate protection. Otherwise, it's useless. Secondly, you have to decide whether your objective is to protect what's inside from outsiders or whether you're trying to protect outsiders from receiving what's in. Now, let me tell you what I mean by that. Many times you see LLCs and corporations that have been traditionally formed for purposes of containing a risk process inside them. For instance, the corporation is going to be involved in interstate trucking. Now, there's something that has a high risk factor even after insurance. There's lots of opportunities for trucks to tip over and do terrible damage out on the highway, kill people, release toxins and things like that. So it's a high risk. Now, that being the case, then they're probable that you want to protect investors from the risk inside the entity. The entity will hold the business, it'll hold the trucks, it'll probably hold all the contracts for their conveyances back and forth of whatever their contents and freight might be, but that's to protect the outsiders from the inside risk. Now, many LLCs, and these are the ones that you'll hear more about, and many corporations are actually used from something entirely the opposite direction. They're used to protect inside from what is outside. Perhaps there's a very valuable family business that makes a lot of money. It's a very good restaurant business, and it's its second or third generation. That business wants to be protected. Its internal risks have well been taken care of many years ago, and it runs like a top. But now everybody that is a member has a pretty valuable interest. And as in all things, people get into troubles out there in the world. It has nothing to do with the company or the restaurant. They drive a car. They could hurt somebody in their car. They can get divorces, and then divorces, of course, try to attach assets. They can incur debts in other areas that they hope for, maybe an investment in another place, and the investment didn't pay out, and now they've got a lot of liability for it. So what they want is they want that valuable nest egg, that beautiful restaurant, to be protected from attacks from the outside in. And that's where a lot of them are being used nowadays, as a sort of a bank or a safe place to put money, or a business operation that's very successful, not a loser, a real money maker, to protect it from all the crisis from the outside. So you want to find a state that also will recognize those options. And then you get down finally to your operating agreement and its actual contents. Now, one of the biggest challenges in most businesses protecting from the outside in have been how do you do that when you've got militant creditors on the outside, say an ex-spouse who's pretty militant usually, or a bunch of people who lost money, or you took out a big loan on a house or a big business you thought was another one you were going to make money on, it didn't work, and now they're all chasing. They're usually very ably represented, and they usually have plenty of money to pursue you. So now what happens? Well, now you've got to protect that asset. Essentially what you have is a membership interest, for instance in an LLC, which we'll use as a best example because it's one of your better mechanisms. Corporations are not as good as LLCs. They are the better mechanism for both of these protections. You've got to have something that is going to protect that LLC interest from being levied upon or attached. Now remember, they can't go directly to your LLC and levy on that business. They can't go, for instance, to the restaurant and levy because grandpa owes some money to an ex-spouse, to grandma. They can't go in there just because he's a member. They have to go after his membership interest. So that's where they pursue. Now, you have to make that membership interest incapable of being executed upon or seized. Now, nothing is perfect. You got to say that right off the bat. Many people go offshore for that very reason, because they make it much more difficult to get judicial process to do any of these things. Remember, a lot of people go offshore because it's a favorable environment judicially, so that if anyone is pursuing them, they have to jump through a huge amount of hoops to do it. For instance, if you're in the Cayman Islands and somebody has a judgment against you here in the United States, to even get there is a huge jurisdictional leap, and it takes all kinds of ulterior filings, U.S. federal court filings, motions to reconsolidate and move farms. It's an enormous process, so that alone becomes a barrier. But let's just say we're here back in the U.S. and Grandma's upset with Grandpa and she's going after his interest for her support. So from that standpoint, what is leviable about that interest? And the answer to that is as much as you make leviable by a poor operating agreement. So what do we do inside the operating agreements? Remember that membership interest is only the creature that you make of it by the operating agreement. You can make any kind of a creature out of it you want. And if you're silent, then it's a creature that can be levied and attached. So you have to speak out and make it not that. One example is a non-alienation clause, that no member's interest can be sold, assigned, conveyed, hypothecated, or alienated, levied upon, or attached in any way whatsoever. And if he does permit that to happen, it is a violation of the membership agreement, and his membership agreement can be forfeit or can be levied upon by the balance of the members. So now what kind of an interest do you have that the moment anybody touches it, it's now a breach to your other members that you've allowed your membership interest to be levied on, and now they can all take action to obliterate your interest and take it completely away from you? Well, it's no interest at all. Also, some people could pass, and then ultimately, where does their interest go? It could go into their estate, or they could be declared under a guardianship or conservatorship, and they can attempt to attach it that way through the guardianship or conservatorship. So you have to address those events too and say, here's what this interest becomes in those events. One of the things you can do if you want to protect people, you could even say that in the event this interest is seized, you're not going to just take it away. In the event there's an attempt of some family member to seize it, then there will be an automatic buyout in which the rest of the membership will buy it out. But how will they buy it? Well, they'll buy it on a promissory note for 60% of then book value, payable at interest only at 3% for 25 years, with a balloon at the end. Okay, so now, does that mean that touching it means that Grandma gets nothing? No, but what it means is touching it means Grandma isn't going to get much of a note. And so it doesn't mean that you expunged it completely, because even that has its legal challenges, that it should just disappear upon touching, because it does have a value. Now you've turned it into a value, but you've set that value so low and amortized the way it is for so long that it's functionally worthless. So that's another way. It means they do get something, but they don't get much. Another one that is very common is to have a shifting interest. For instance, if it's only the husband that has the issues, it shifts to wife. Or you always have another interest holder in your entity. It could be a child. Maybe they're a 1% holder, and by virtue of any levy or attachment, all of that interest shifts over to the other person. And if anything, there's just a capital shift inside the organization, and it could even be a gift. If it's a gift that's not, it still doesn't reach creditors, it's not anything that they can benefit from. These are the kinds of ways where the moment that they touch that interest, it turns into a puff of smoke. Now, there are issues, and I think we're going to get to them a little bit later, such as charging orders. What happens, for instance, and I'll just briefly cover that, if the interest now is totally untouchable, unalienable, and in the event you even do try to touch it, it suddenly changes into some weak promissory note that lasts for the balance of everybody's known life and then some. In that case, some states have allowed a charging order. Not all states do. Now remember, I said choose your states, but many states don't have a charging order. But even those that do, the charging order, if you read the statutes, for those that have them, can reach certain elements of the interest. For instance, some states have charging orders that allow the creditor to seize the entire limited liability or LLC member's interest and actually sell it at auction, and very much similar to a garnishment or an execution. Those are not the states you want to be in. But in those states, if you happen to be there, that's where you beef up these forfeiture and buyout clauses, because remember, they only get what the operating agreement says they get in the event of levy or execution. Other states say they can only levy on the income to the member. So that means that in the event that membership ever has paid any dividends out of the LLC or paid any interest, then they can reach that if and when it's ever paid. Now, what would that tell us? The Smart Operating Agreement says in the event that there's any alienation whatsoever, voluntary or involuntarily, of your membership interest or any dividends, benefits thereof, then what? Shifts to the other party. There won't be any from that point on. They'll actually accumulate for a period of 25 years and then be given to the grandkids. You can actually turn these into a little mini will, as long as you write it appropriately, that shifts all those benefits elsewhere. So then what is the value of the charging order, even in those states that grant it? So one has to read not only the state to determine if they even permit charging orders, but also read it to determine what the charging order can actually reach and when. And as you can see, if it can only reach income if it ever comes out, many of these family LLCs don't pay out any current dividends. Now, let's say that Grandpa actually doesn't just get paid his distributable share of income of the net profits of the company, but he's also paid a salary. Now, if he's paid a salary, that could be reachable by execution and garnishment because it's separate. It'll stand on its own. But do remember, in most states, they also have exemptions. And one of the exemptions in most states, those are the things that can't be levied on attached. They don't even go into bankruptcy, is large disregards of salaried income, so that the people will at least have a living wage. So Grandpa would be entitled to all those large disregards, even of his wages, that otherwise wouldn't be applicable if he was taking his dividends under his LLC. And so suddenly now he's still paying maybe a levy on only 20 to 30% of everything he makes. These are the ways to limit, to make unattractive what a person can otherwise pull out an irate creditor of these entities. And here's what usually it comes down to. There's so many hurdles for them to get across that when the creditor looks at all of them, the creditor gets tired. And that's usually the time to strike with a resolution. In other words, that's about the time when they see that they're going to have to run this gamut and then that gamut, and then you'll see them here and then you'll see them there in the various jurisdictions in order for them to maybe get some money someday. Meantime, they're spending a fortune to do it. It's usually about the time that they're extremely motivated to settle that debt for pennies on the dollar. And of course, once it's settled, it's not there at all. Everything goes back to normal, and that crisis is over. So many of these also use one other element that I didn't mention, and that's what I called I mentioned it briefly, which is called the forum inconvenience, meaning that in order to even get to it, they have to jump through a lot of hurdles. And one of those is, for instance, in California, if you have a judgment against an out-of-state LLC, but all of its assets are in that other state, can you levy against it in California with California garnishment and execution? Answer no, because California garnishment and execution can only reach what is inside California. It's either there direct, the entity is there in some fashion that makes it leviable in that way. But even if it's trying to levy against an LLC, California law says, as using it as an example, that it will respect the law of the foreign jurisdiction if the LLC is from a foreign jurisdiction. So let's say your LLC is from Nevada. In that case, California isn't going to be able to levy or attached, and you're not even going to be able to take your California judgment and send it to Nevada because Nevada will not recognize a California judgment. It'll laugh at it. It's an abusive process. What you have to do is you have to re-domesticate the judgment all over again by filing in Nevada, making the claim all over again, and then getting a judgment. Now that takes a long time. And in the interim, you could even be moving that asset to the next company because you got plenty of warning, sometimes as much as a year that they're even trying to do it, costing them a fortune to do that. Meantime, you know, you're regrouping the wagons elsewhere, or let's say it even ends up with a judgment and you sit right where you're at. Again, Nevada has a very limited use of the charging order and a limited ability to penetrate that LLC. And if your operating agreement is written appropriately so that none of these are leviable, none of them are distributable, and none of them are going to pay any dividends during a period of crisis, they still end up with a judgment against precisely nothing. Now, it's true they're sitting at that door and they're waiting and waiting to see if they're going to be able to ever have you get paid anything. Meantime, your business is probably starting another business elsewhere, deciding to do business with it, and investing from the inside of this LLC to another LLC. So meanwhile, the assets inside this LLC are dwindling down to pretty soon they're worth, pretty much nothing. So these are the reasons that people will use these in order to protect wealth that it's taken them years to accumulate. Now, if it's illegal wealth, different story. Of course, if you're getting it from white slavery or drugs or gun running or something like that, or if it's a violation of some of the anti-terrorist acts and you're actually laundering money, then none of the above apply, because it's all can then be reached by at least the government and the policing authorities under civil racketeering claims, which can penetrate most of this because it's just followed the dirty money. In that case, then you're just dirty, and they can penetrate it and then go right through entities. That's not a problem. They call the entity itself as another one of the defendants in the case, and you personally right along with it. So there's some of the benefits that a person can obtain with LLCs and artfully written corporations that have bylaws that are very similar. They call them poison pills. You've heard of poison pills being used all the time. Like they say, one corporation was about ready to eat the other, but there was a huge poison pill. Well, what does that mean? It means if you try to swallow me, there's a very bitter pill that goes with it, such as you have to buy out all the senior stockholders for 5 times what their stock is worth. Or we have the right automatically then to sell ourselves to this group over here for next to nothing, all of our business. And that poison pill was here before you showed up. Therefore, if you want to gulp it, then you're going to take the poison pill right with it, which means you get nothing. And those are used not so much that people do them, that the company then gulps them down, but they use them to ward off the vampires. It keeps them at bay. They don't bite into the poison pill because they know that's precisely what's going to happen. So most of these are just warning signs and barbed wire. Very few of them actually have to go through the whole exercise, because if they're drafted right and put together right in the first place, the mere challenge of attempting to reach them and the likelihood so great that you're going to be unsuccessful as a creditor shies most of them away and makes fertile grounds for settling your case.
Perfect. So just guys, more in this thought, in this powerful idea and concept of customization. It's your corporation, it's your LLC, and it's up to you to make it work in the way that it protects you and itself.
Well said. Thanks, Mark.
Thank you.